Unsubscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. Affair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, Archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website.
All rise. The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We are here on file number 2025-0258, State of North Dakota versus Kendrick Romaine Baker. Sitting today are Justices Daniel Crothers, Justice John Jensen, Justice Douglas Barr, and I am Lisa Fair McKevers. Justice Jared Tufte is unavoidably absent this morning, but will be participating on the briefs, the record, and review of the oral argument at a later time. Appearing today and arguing today for the appellant is Kiara Cross-Parr, and for the state, the appellee, Nicholas Samuelson. Ms. Cross-Parr, you have 10 minutes reserved for rebuttal, and you may proceed when you are ready.
Good morning, Madam Chief Justice, Justices, Counsel, may it please the Court. I am here representing Mr. Baker. There's a few issues before the Court. The third issue, the state has essentially conceded or agreed with us, so I won't spend any time on the illegal sentence issue.
What if we don't agree with the state?
What's that?
What if we don't agree with the state?
Well, we can certainly discuss it. It'll be the quickest part of the argument. So essentially what happened was the court at sentencing essentially removed Mr. Baker's good time credit, which this court has repeatedly said is an administrative function that the jail or whatever the facility holding the incarcerated individual, that's their responsibility to either grant or remove good time. It's based on their own administrative policies and procedures, and so that should be up to that administrative body to do it. And the courts did not have any authority to remove those credits because the jail administration didn't.
Where was Mr. Baker being held?
Cass County. Local
Is
jail.
good time accrued outside of the prison?
Yes, so the statute is, there's two statutes, one is for DOCR and one is for local facilities, and the statute for local facilities is 1 day for every 6. So that would be the amount of time accrued, is 1 day for every 6 days in custody.
Is there agreement on the number? Because there's nothing in the record that suggests the amount of good time. The state says 46.
Yeah, and actually, Mr. Samuelson and I had a discussion, and he thinks his numbers were actually a little bit off, and so there might be 8 additional days. I didn't calculate it.
So the agreement is not with respect to the number of days that needs to be determined.
Yes, yes. All right.
And was Mr. Baker sentenced when he was in county jail?
Yes,
So we're talking about good time after he was sentenced, that he was spending in county jail.
no, I'm confused about your question
Well,
now.
isn't there a difference between good time and credit for time served? In other words, if he's being detained on a charge, you get credit for the
I
time
understand what
served.
you're asking.
You're talking good time here.
Yeah.
And he's not sentenced.
No, but the statute contemplates credit for meritorious conduct while awaiting sentence as well. So I don't, again, the state and I are in agreement, not maybe about the time. I haven't actually calculated the time, and I think the state just thinks that his calculations was perhaps off by a few days. Again, this is an administrative decision. The reason it's an administrative decision is because that's who is housing these individuals. It's their sort of carrot and stick to get people to participate or to act appropriately while incarcerated. So that's why it's an administrative decision and not a judicial determination. But the statute says that the court has to include it in their sentencing. So that's where we get sort of this overlap. To discuss the other two issues, the state points out in their brief that I didn't argue this under obvious error because it's not an obvious error. They misconstrue the argument. The convictions are in and of themselves not necessarily the issue. So that happens all the time at the federal level. It happens quite often in Minnesota where an attempt and a completed crime are charged. And I see it quite often in drug cases. So possession is charged.
Procedure, I'm sorry to interrupt again,
Sure.
but procedurally, how do we reach the question, this double jeopardy question?
Yeah, it generally is at sentencing where this is brought up, and it is, so in my experience, either in a federal case or I've handled cases in Minnesota where this is brought up, where they have a jury verdict that has essentially found them guilty of the inchoate attempt and then the merged crime, or what that would be the merged crime, and then the completed crime. The sentencing court only sentences in one crime. Essentially, so how I've seen it done is you have a possession charge and you have an attempted.
So do we look at it as an illegal sentence, that you can be convicted of both, but you can't be sentenced, or can you not be convicted of both?
So in my experience, you can be convicted because the conviction is from the jury verdict, but you cannot be sentenced because it's the punishment that's the double jeopardy problem. I suppose although I've never seen it done, but if I'm thinking sort of logically and hypothetically, I suppose if you could make an argument that the conviction alone without any sort of punishment is a punishment, like maybe you had no other criminal history and now you have 2 convictions which could then negatively impact you. I suppose you could make that argument. I've never seen that argument made. I've always only seen the argument that it's the dual sentences that's the problem.
But you really can't challenge the convictions because that was waived. No obvious error was argued about the
And
convictions.
I've never really seen that. I'm certain that maybe someone somewhere could maybe make that argument, but I've never seen that be successfully made to a court. Now, I don't know every case everywhere, but I certainly never have seen that done. I have certainly seen jury verdicts for an attempt and the completed crime numerous times, and how it is handled is always at sentencing. And as the state points out in their brief, as I point out in my brief, that is the argument that the defense attorney made to the court, that this shouldn't be sentenced in both cases. And that is the crux of that argument, and I don't believe that obvious error is necessary. We should probably look at what the actual substance of the argument is. And the jury instructions, because that was the crux of the argument below as well, is that there's a attempted GSI. In accomplishing that attempted GSI, there is let me back up. There's an attempted GSI sexual act, and there is a completed GSI contact. But that was all one course of activity. The course of conduct, the substantial step is the completed crime of sexual GSI by contact. That is the thing that is the attempt of the completed GSI by, now I'm getting my language confused, but the attempt crime is what led to the attempt crime is all of the allegations were that he held her down, removed her pants, and essentially was attempting to penetrate her, and was unsuccessful in that. The state in their briefs as well, you can't, and under Blackburger, you can't argue facts to show that this is a lesser included, but then goes on to argue that the jury instructions were fine because the state argued in their closing that you should look at these facts for this and this facts for that, but that's not what the jury instructions told them. The jury instructions were simply a substantial step. So and while they had to be unanimous about what the substantial step was, the substantial step could have been the completed GSI by contact, and they could have all agreed that that was the substantial step. And given the nature of what was alleged to have happened, would make logical sense. So the state's argument doesn't really cure the problem of we have a attempt that should have merged into, you can have the convictions for both or the return of guilty for both, but then at sentencing you cannot, because of the merger of the attempt into the actual completed crime, it's not possible to sentence in both cases. That was one issue. The second issue on
that, if we agree with you,
yeah.
Both convictions carry the same penalty, right? Do you argue which one is the one that should remain and which ones shouldn't?
Yeah, and it was a concurrent sentence, I do understand that, but it doesn't really change the fact that you can't do it.
No, but my question is, if the court agrees with you,
Yeah.
which one is vacated?
Generally speaking, that's up to the court when so in my experience, when there's these two convictions, attempt and a completed crime, what generally happens is the attempt is not, it merges into the completed crime. That's generally what occurs, but it's really up to the court. The doctrine just says you cannot have double punishment. So I mean, you could, I guess, pick the attempt. I've never seen that occur. It's usually because of the nature of an attempt crime, it merges into the completed crime.
Your brief asks us to vacate all of the convictions.
Yeah, because I was uncertain how to get around, kind of what your question was, how to get around what they found him guilty of. So, did they find him guilty of the sexual contact by force, and that was the attempted gross sexual imposition?
Well, it's Justice Barr's question. If we agree with your argument that this is, you cannot be sentenced to both,
right?
Aren't you sentenced to one of them? And then we figure out which one?
Yeah, I just don't know how you're going to figure out which one.
Do we figure out which one, or does the district court figure out?
The district court does, yeah. I mean, that's typically what should have occurred, is essentially,
Unless
yes.
the one is the lesser included.
Right.
Then you can't be convicted of that.
Well, again, it merges into, yeah,
Right. So it'd be the greater.
yes. But they're both double A's, I believe, so.
Not greater in penalty, but greater in crime. It would be the superior as opposed to the lesser.
Oh, I understand what you're saying now, yeah. Yes.
So could the district court if we agree with you and one of them can't be the basis for a sentence, can the district court increase or decrease its sentence?
So,
Does it have to impose the sentence? For example, if it picks the actual charge, the gross sexual imposition, does it have to impose the same sentence, or can it go back and decide, well, I can only sentence you on one of these, so I'm going to increase the sentence?
so no is my short answer, and here's the reason why. Although we don't have any case law in North Dakota, I have looked at this issue at the federal level, and the cases, although nothing from the U.S. Supreme Court, but from district courts circuit courts at the federal level, say that it's essentially punishing someone who's exercising their right to review, that you would need to.
You have a statute that addresses the issue too, right?
If we do, I can't recall it off the top of my head, but essentially, without some additional factual input, there would be no meritorious reason, unless you're referring to that they've, I'm thinking of the case where it was the judge sua sponte changed the made a Rule 35 motion and changed the sentence, but it went lower. And this court said, you can't do that, but we can't actually fix it because we can't increase the punishment. I'm blanking on the name of it, but, so no would be the short answer to that. I think that the sentence in whichever conviction remains would be the sentence that's already been imposed. And then as to the lesser included, excuse me, for kidnapping, for felonious restraint, this is a little bit factually different from the case that says felonious restraint isn't part of a GSI, because this is a part of an attempted GSI where what you're saying was attempted was the forcible restraint, the felonious
The
restraint.
attempt charge goes away? Does this argument go away?
Well, as we've discussed, I'm not sure that the attempt charge really does go away. There is a verdict that says you're guilty, you just can't be punished for that again. So we have the same problem, but slightly different in that this is a felonious restraint that very clearly would go into the allegations of attempted gross sexual imposition, where we have, because we don't need the completed act, and that is what the problem was in the case that I was citing, and I think the state in their brief cites as well, is that there needs to be the reason why felonious restraint generally isn't a lesser included is because State v. Smith, that's the case I was thinking of. The reason why it's generally not included is because in GSI, you need to have a sexual act or a sexual contact, one of the two. And you don't need that for felonious restraint. But the thing with attempted is that you don't need that. That's the whole point of attempted, is that you can just have the felonious restraint, and that can be your substantial step into the GSI. So
Was this issue raised at the district court?
That one I can't actually remember. Because I did include the language where they very clearly said this is, there's multiplicitous charges in this.
Well, I ask, your brief is supposed to tell us where it was preserved.
Right, and I don't know that it
I didn't
was.
see it in the brief, and I didn't see obvious error argued either.
No, I didn't argue obvious error. Lesser included, I just think it is a lesser included. I don't know that it was specifically preserved. I'm not sure, to be honest. I do recall there was a conversation with the defense attorney about the multiplicity of the charging. And I know that this is perhaps not preserved. I honestly can't tell you 100% that it was or it was not. If it was not, I do feel like I would have done an obvious error, but off the top of my head, I can't point you in the right direction for where in the proceedings that it was preserved. It would be completely an issue of, again, double jeopardy, in that you cannot punish someone multiple times for the same course of conduct. And so we get to the same problem that we have in the counts for 1 and 2, the GSI by contact, GSI by sexual act. And I think that's the way I actually framed it in the brief, is that we have the same problem, is that you're punishing the same conduct over and over and over, and you can't do that. So even if the conviction stays, the verdict stays, you cannot sentence again for the same conduct. That's the problem. And I don't think that needs to be argued under obvious error, because that's just whether or not the elements allow the district court to sentence the way it did. That's really what we're looking at. It's a purely legal question that can be reviewed de novo. Does the way that the elements work in this case allow for multiple sentences with these charges? This is not something that I don't know that you could have preserved it without having first gotten a sentence. If the district court had said, well, we have these 3 separate jury verdicts convicting you of these 3 separate crimes, but they're all the same conduct, so I'm only going to sentence you in, say, the completed gross sexual imposition. That's what I'm going to sentence you for, because the other 2 crimes merge into this, then there would be no appellate issue. But because that didn't happen in sentencing, that's why there's an appellate issue, so I don't know.
But you argue, and I think the record shows, the issue was raised with regard to counts 1 and 2.
It is.
But not that it was raised regarding this count.
So the reason I'm arguing it the way I am is because the court could have done an appropriate sentence and there wouldn't have been an issue. The verdicts themselves are not the issue necessarily. It's because I argue this under a double jeopardy standard, which means that you can't sentence them for 3 different crimes when it's all one crime, essentially. It's all one conduct. So you can't sentence them repeatedly for the same conduct. It's essentially the double jeopardy argument that I make in this issue and in the issue above. And that's the real problem, and there's no way to get at that until the court sentences. Once the court sentences, then we're on appeal, and it can be reviewed de novo. So that was a long-winded way of getting around why I don't think it was, perhaps not preserved in the way you mean, but I don't think that it needs to be the way. The problem would only arise at sentencing after the judgment's in, and then you appeal from that. So with that, I think I've addressed all 3 of the issues, and I will reserve the rest for rebuttal. Thank you.
Thank you, Ms. Crosspar. Mr. Samuelson, when you're ready.
Thank you, Chief Justice McEvers, Justices, Ms. Crosspar, and may it please the court. Mr. Baker presents 3 issues on appeal, and I'd like to take them out of order and address the 3rd one first, because as Ms. Crosspar alluded to, I have a correction to make. I made an arithmetical error in my brief regarding good time, and the figure should be 54 days. I stated 46 days in my brief. I'll get to that calculation here in a moment. In response to a question that Justice Crothers asked, good time at sentencing comes in under North Dakota Century Code 12.13202, subdivision 2, which says in relevant part, the total amount of credit the defendant is entitled to and time spent, for time spent in custody, and any credit for sentence reduction under section 12.144.1 or 12-44.132 and 12-54.101, the defendant is entitled to must be stated in the criminal judgment. So under 12-44.132, the good time provision for county correctional facilities, Mr. Baker is owed 1 day of sentence reduction per 6 days served unless administratively revoked by jail.
Is he owed it, or does the facility say he does get good time? Because he could have not been good while he was sitting in custody.
Fair point, Your Honor.
I mean, my understanding, a facility needs to confirm they get this good time. The court doesn't get to decide that.
Correct, Your Honor. The record is slim but not bare on this point. The sentencing prosecutor conveyed to the district court that her understanding is the Cass County Jail always credits unless there is an administrative revocation, and there was no indication there was an administrative revocation here.
I would like to follow up on Justice Crowther's question. I don't know if you have 1244.132 in front of you, but it starts out by an inmate sentenced. He's not sentenced while he's being held, right?
Right.
So how does 1244.132 apply to the defendant in this case before he's sentenced?
It's always been my understanding, Your Honor, that this applies.
That may very well be, but it seems pretty unambiguous, doesn't it?
It does, Your Honor, and I hadn't considered that angle.
And then if we look at 1254.101, which is the other statute that both parties rely on, that clearly only applies to the Department of Corrections, right? Because the word department, which is a reference to Department of Corrections, is referenced twice in that sentence.
Correct.
So what other statute do we have that provides a pre-sentence good time credit for a defendant?
My understanding is this has always just been local practice, and perhaps we've all been reading the rule incorrectly.
Can we answer that question despite the state's concession?
I suppose this court could agree with the district court on different grounds. The district court seemed to indicate that good time was not owed because of Mr. Baker's poor conduct while incarcerated pretrial. But if he's not owed it under the statute, I think this could be an example of this court affirming with the district court being right for the wrong reason.
Okay. Thank you.
I'll turn now to the first issue raised in Mr. Baker's brief, whether count one, that being the gross sexual imposition by sexual contact, and count two, attempted gross sexual imposition, sexual act, were multiplicitous and thus created a double jeopardy problem. In my brief, I argue this was not preserved in the district court, and perhaps because of Mr. Baker's brief asking for vacation of counts 1, 2, and 3, I didn't fully comprehend exactly what was asked here. It seemed that he was asking the court to get rid of both the attempted GSI and the GSI, but I stand by that these were not properly preserved. There was no request to dismiss one of these. There was a...
But that's not the request now either. See, they're not challenging the sentence. They're challenging the sentence, not the conviction. And
Sure,
that was raised specifically at sentencing, correct?
It was. I would argue that it was maybe half-baked because it was, I think there's a case out there somewhere, and I don't know what the
But
case
enough
is.
to put the court on notice.
Sure. And the court, I think, did largely agree with Ms. Kite, the sentencing counsel for Mr. Baker, in that it sentenced counts 1 and 2 concurrent. I suppose if that is an issue, and you know, my comprehension of this case was a little bit different than what was fleshed out in the first 20 minutes here, the remedy, I suppose, would be to vacate count 2 because it's the lesser. I disagree, And as I laid out in my brief, I think counts 1 and 2 are distinct and not one in the same. One isn't a lesser included of the other.
If we disagreed, which one should be vacated, or is that to the district courts?
2 should be vacated because under
That's the attempt?
That's the attempt, because that would be the lesser included. Here, the jury was instructed that it must unanimously agree on which specific act or acts constitute the element of a substantial step regarding count 2, and which specific act or acts constitute the element of sexual contact. So I would argue that the unanimity requirements here, coupled with the evidence, coupled with the arguments, show that counts 1 and 2 are separate and distinct.
How do we know the jury didn't agree that all of the acts, they had to unanimously agree what the act was, but they don't identify what the act was for the attempt. So how do we know from the verdicts that the same act of complete GSI was not the same act for attempt?
I think, Your Honor, just what was presented as evidence, the presentation indicated the count 1 was for dry humping and or ejaculation, and count 2 was for attempted penetration.
But then, in the state's closing, the statement that was made for count 2 was, same thing, tried to insert but failed. When there's an acknowledgement that it's the same thing in the closing argument, what do we do with that?
If the court disagrees with me, I would ask the court vacate count 2, which would not change functionally the sentence, because he's sentenced to 20 years on count 1 and count 2 concurrent with one another.
Do we vacate the conviction or do we vacate the sentence? Again, this kind of goes back to, is double jeopardy a sentencing problem or is it a conviction problem?
Don't know the answer to that. I'll turn ahead then to the second issue raised in Mr. Baker's brief, which is the multiplicity of counts 2 and 3. Count 2 being attempted gross sexual imposition by a sexual act, count 3 being felonious restraint. This court is no doubt aware that the Blockberger test is the operative test here, whether the same act or transaction violates 2 distinct provisions. We look to whether each statute requires a separate proof of fact that the other does not. We've got some case law that's not directly on point, but is very close in State v. Smith, where this court held that felonious restraint is not a lesser included offense of gross sexual imposition, the actually consummated version.
Mr. Samuelson, and correct me if I'm wrong, you're arguing that this issue was not preserved. If it had been preserved, would the district court should have the district court been presented with the factors and the district court applied the Blockberger test here?
Yes, the district court should have been presented with this through a motion to dismiss, I think would be the most proper, but or some objection, something, an argument at the preliminary hearing, something along those lines to raise the issue. This was never raised until we got to the appeal, certainly. Because it wasn't preserved, we're under an obvious error framework, and I think under the first prong, whether there was error, we can reach the conclusion that it was not error. Gross sexual imposition, or attempted gross sexual imposition, requires proof of intent to commit gross sexual imposition and a substantial step in furtherance of, but does not require any proof that the victim was restrained Certainly, as I noted in my brief, there's a vast universe of things that could be a substantial step, and one of those could be the same facts that make up a felonious restraint, but it could also be terrorizing or aggravated assault or any number of other things. And under Blockberger, that's what we're looking at, is what is the element, not what is the conduct. Likewise, felonious restraint requires proof that the victim was restrained, but does not require any proof of intent to commit gross sexual imposition or a substantial step toward the commission of that offense. So under Blockberger, under the first prong of obvious error, there is simply no error here. There's been no argument on the second or third prongs, so this court, I would argue, should not engage in an unassisted search for obvious error, whether error was obvious or whether there was prejudice. There's simply no argument on obvious error for the second contention that counts 2 and 3 were the same offense. So if there are no further questions, we are asking the court to affirm the criminal judgment. Thank you.
Thank you, Mr. Samuelson. Ms. Kraus-Park, you have 10 minutes.
Thank you. I did want to circle back around to the part of my brief that I thought was going to be the most straightforward in the sentencing issue. The court has raised a 12-44.132, which is what I quote in my brief, which the state quotes, and that does correctly point out it says sentenced. However, when we were discussing it just earlier, what I was referring to also is the actual sentencing statute, 12.13202.2, which is the credit against any sentence to a term of imprisonment must be given by the court to a defendant for all time spent in custody as a result of a criminal charge. It goes on. And then time spent in custody includes time spent in custody in a jail or a mental institution for the offense charged, whether that time is spent prior to trial, during trial, pending sentence, or pending appeal. The total amount of credit the defendant is entitled to for time spent in custody and any credit for sentence reduction under Section 12-44.1-32 or 12-54.101, the defendant is entitled to must be stated in the criminal judgment. So,
but again, it makes specific references to those two statutes, and if it doesn't fall under those two, how do you get good time in?
because it says any credit sentence reduction under those statutes, and the statute.
Right, under those statutes, but if neither of those statutes apply, how do you get the good time?
Those are directly good time statutes.
But
so
how do they apply to this case? How does either of them, if 12, it has to fall under either of those two statutes, correct? That's what the statute says.
It says any reduction owed, so.
Under those two statutes, right?
Right.
Okay, so if the one statute requires sentencing in the local correctional facility, that's 1244.132, and the other statute expressly applies only to the Department of Corrections and the penitentiary, how does it fall under either of those two statutes?
Because it's the only way for the person, you would not have any, the way that you're interpreting that's the sentencing statute would mean that no good time is earned.
No, not at all. If you're in the state penitentiary, clearly, 1254.101 gives you good time. If you've been sentenced and you're being held in a local facility, you get credit for good time. It only excludes pre-sentencing. And it doesn't exclude it. It
does. That's my point.
No, the statute includes, the 12.13202 includes good time if it falls under 1244.132 or if it falls under, I can look up the
54.101 sentence reduction.
54.101. The statute's what's ambiguous about that?
Yeah, the problem is what I just said, that only people who are actively serving a sentence will get good time reduction on a new charge.
That's correct.
Yeah, there's an equal protection problem there. So if you have no prior sentence that you're serving, you don't get good time credit for for this, so you have no other criminal conduct. You are sitting on this charge and this charge alone. You don't get good time conduct.
That's correct. That's what the statute says.
No, it doesn't, because the statute says they are entitled to sentence reduction.
If, right? Under, and then it lists two statutes.
So you
Tell me which of these two statutes includes it. You're not answering my question. You keep going back and arguing, well, it has to include, without telling me which of the two statutes that are referenced does it fall under.
I'm trying to read the statute to be based more on affirmatively on what you're asking, but the problem is that you are then giving some people, we have similarly situated defendants.
No, they're not.
Yes, they
One
are.
is sentenced, the other is not.
No.
Yes, one is sentenced, the other is not. That's not a no.
It is a no, because let me explain. You have defendant one, he's charged with theft, and you have defendant two, and he's charged with possession. And they're both pending, their case is pending, and they're both sitting in custody locally, say. Defendant one is also serving on some other sentence. He's getting credit for DOCR custody or something else that he's sitting there getting credit for, which would give him good time reduction. Defendant two has no other charge. He's only sitting for the crime that he's charged with.
He hasn't been sentenced. That's a pretty significant difference.
But when we get to
you're trying to compare the two unsentences, but then you're referencing a sentence.
Well, that's what I'm talking about, is that
If
when
there
we
are
get
two people who, neither of which are being held on a sentence, okay?
Yep.
Neither of them. They're treated exactly the same. If there are two people being held on a sentence, they're treated exactly the same. The only time it's different is when somebody is being held not sentenced and somebody is being held sentenced.
No, the defendant one and defendant two are both being held in local custody.
Right.
But you're saying the defendant one, who has is accruing good time through some other conviction.
Correct. On a different
It's
sentence.
Good time there. When those two get to their ultimate convictions for the crime that they're sitting on locally,
Neither of them would get credit for good time on that second sentence until they are sentenced.
then the statute under sentencing doesn't make sense, because then no one gets good time when they're sentenced.
No, that's absolutely not. That second person that has both a non-sentence charge and a sentence charge is getting good time on the sentenced charge.
Where?
The statute applies.
Where? They're
On
getting,
their sentenced charge.
so only after they're sentenced. That's what I'm saying.
That's what the statute says.
That's,
The statute's unambiguous.
but somebody, the person who, I disagree. The person
What's
who,
ambiguous about it?
because the person who has,
Point to the language in the statute that is, don't answer another question or go.
Sure.
Point to language in the statute that's ambiguous.
yeah, so where I think that I disagree with you is that the credit against any sentence to a term, so in the sentencing part of the statute, so under 12.13202 under sentencing alternatives, the statute specifically says any credit for sentence reduction.
Keep reading, though. You can't read part of a sentence and say it's ambiguous because you don't want to read the second part.
No, because based on the way you're interpreting it, no one would ever, at the time of sentencing, no one would ever receive good time credit.
That's correct. That's what
But
the
then
statute
that
says.
sentence doesn't make any sense.
Read the
then.
whole sentence.
No, but
No, stop.
I understand
Read
what you're
the whole-
saying.
no, stop.
Under section 1244.132.
Indulge me and read the whole sentence.
Okay. The time spent in custody, any credit or for sentence reduction under 1244.132 or 1254.101, the defendant is entitled.
What's ambiguous about that?
Because the way you're interpreting it, the way that you're reading it, says that nobody pre-sentence, so you were just convicted and you get sentenced, nobody gets good time credit. You have to have had a sentence, be sent to DOCR.
Without a doubt, that's how I'm reading it. Because it's unambiguous.
No, I disagree, and this is why it's ambiguous, because you wouldn't need this sentence at all. Zero need for this sentence in
Oh,
this.
you would, because
No.
in order to pull in the good time, you have to reference those two statutes. That's how it's done.
Gets good time. Based on the way you're interpreting the statute, nobody gets good time, so this would be a meaningless sentence to put here.
Oh,
'Cause this
everybody
is-
gets good time if they've already been sentenced.
Oh, but the sentencing court doesn't do that. The sentencing court is, so you're convicted of assault or whatever, and I am the district court and I am sentencing you to whatever your sentence is. Based on the way you're interpreting it, you have no prior sentence, you have no prior anything, so you don't get good time. I am sentencing you on this. Then this is superfluous language. You don't need it in here. Because this is all about sentencing and alternatives to sentencing. You wouldn't need that provision about credit against, reduction of sentence in this section of the code. It wouldn't be unnecessary.
Could that be to put the Department of Corrections on notice in the case that they've already been sentenced on, that they were good in the county jail or the regional correctional
Jail
facility?
can do that. The court doesn't need it. In fact, it's administrative. The jails can do that. That's what typically happens. So I disagree with your interpretation, although I understand what you're saying, but I think that this language would be superfluous if you read it that anytime the district court sentences for the first time, there's no consideration of reduction, because that doesn't make sense to the way this is put into the sentencing part of this statute. Thank you.
Ms. Grosspar and Mr. Samuelson, thank you for your arguments this morning. This case will be taken under advisement, as all cases are, and court will be adjourned until 1:30 p.m.